Dirk, thanks for speaking with our organization, German Lawyers for International Law. For those who don't know you yet, Dirk Moses is an Australian-German historian and genocide scholar. You are the Anne and Bernhard Spitzer Professor at the City College of New York. You became widely known for your groundbreaking contributions to genocide studies and to debates on memory culture. Your book, The Problems of Genocide, examines the origins and political functions of the genocide concept itself. As editor of the Journal of Genocide Research and as one of the leading experts on the history of mass violence, you've had a significant impact on international law and genocide scholarship. Dirk, there are currently major proceedings against Israel before international courts in The Hague. Looking at the current situation, how do you assess the significance of the two proceedings against Israel?
I mean, they're hugely significant in a number of ways. One is politically and symbolically, because it's the first time that a Western-oriented state has been hauled before the ICJ on this kind of charge. I mean, as you know, the Gambia launched proceedings against Myanmar for a similar kind of charge several years ago, and that case, when it's determined, will be very important for the outcome of the South Africa Israel case. But in that case, with the Gambia, you had Western states backing this African state's application and providing Gutachten, reports and support. But they're not doing that this time. They're arraigned on the whole on the other side because one of their client or allied states, partner states, is in the dock. And so the whole world is looking on to see how international justice actually functions. Now, the legal aspects are also significant, obviously. Everybody wants to know how you determine genocidal intent, how this can be inferred from a pattern of conduct and all the measures or the stipulations that have been set out by the ICJ in previous judgments, for example, in its Bosnia cases. So everyone's looking with bated breath. And I myself am not necessarily optimistic because the jurisprudence is very conservative, and I try to explain how and why that's the case in recent articles.
From your perspective, what lies at the core of the problem with the concept of genocide?
So the concept itself, before it was codified in law, so in Lemkin's first running out of it in his book in Access, Rule and Occupied Europe in late 1944, which he finished a year earlier, mind you, he combined the notions of persecution and discrimination and the attempt to cripple, is a term he used, a nation with destruction. It was an extremely broad definition. And in my research, in trying to figure out what Lemkin intended, became apparent to me that he was proposing a new concept for the coming Nuremberg trials, because the international debate from 1942 onwards on the Western side or the Allied side was, well, there are going to be war crimes trials after the war, but what laws will we use? And they didn't work so well after the First World War. So we need to do a better job and we need new laws. And so there's an international debate about, is it crimes against humanity? Is this a legal concept? Can we invent new concepts and new laws? Is that just? And so forth. And Lemkin then proposes this new concept, which isn't taken up in Nuremberg. In any event, he does so because he understands that there's a rift between the small nations of Europe, which are occupied by the Nazis, including his own Poland, Czechoslovakia, and so forth, and the World Jewish Congress, with whom he was in close touch. And the World Jewish Congress wanted a separate indictment at Nuremberg for crimes against the Jewish people, so a very particularistic one. And the small nations like Poland, Czechoslovakia, and the Americans and the British, mind you, were resisted that because, of course, Jewish victims were citizens of all these countries in Europe, right? And they wanted sovereignty over their citizens. They weren't going to let a non-government organization like the World Jewish Congress represent them. So you had these kind of tensions going on. And Lemkin saw that there was a rift in a way between the allies. So he tried to come up with a bridging concept which would encompass the specificity of what happened to Jews, and he has a chapter on that, chapter 8 of Axis, Rule, and Occupied Europe, with total destruction, which he understood even by then, although he was writing earlier in the war, and the kind of cultural and political genocide of the Polish nation, the Czechoslovak nation, and so forth, that he saw the Nazis also intended, but not through mass extermination, but through other forms of destroying a nation. You could destroy a nation in many ways, but that meant that you, in one concept, you wedded mass murder and extermination with, for example, cultural genocide or moral genocide, which he had examples like, inculcating alcoholism and pornography in a nation in order to debase it, so it's no longer imbued by a lofty national spirit. Now, when it came to the codification of the law after the end of 1946, when the General Assembly of the United Nations resolved to have a genocide convention, then spent 2 years trying to do so, delegates at the UN said, that doesn't make any sense. They're separate concepts, persecution, discrimination, and so forth. Although they may be, precursors to genocide, they're a discrete process. So, as you know, persecution is now a crime against humanity. And it's also an identity-based crime. So it's very similar. When you look at the wording, it's very similar to genocide, but it's persecution and not destruction. Right? Destruction is the verb or the intent to destroy in the Genocide Convention. So these things are disaggregated in law. Now, the benefit of Lemkin's broad definition is that you captured so much. And this has been inspirational for indigenous people because cultural genocide is included. The downside is that it does feed into kind of an ultra-nationalist ontology of the human cosmos in which, the nation is primary and the, national spirits exist and need to be protected before all else instead of, say, individuals, and for example, it allows or drives claims like the Russians today in relation to the Russian-speaking Ukrainians in eastern Ukraine to claim that those Ukrainian Russians are victims of genocide because the new Ukrainian government insisted that they learn Ukrainian first and foremost. And Putin then says, well, this is the destruction of the Russian people in Ukraine. I mean, and the ICJ threw that out quite rightly. So it's that reservation that drove the legal restriction of Lemkin's definition so that it can't be used for those kind of propagandistic, expansionist, irredentist purposes. I mean, the downside of it, though, is that by making the definition of intent so restrictive, like the intent to destroy in whole or in part an ethnic, racial, or religious group, as such, it's almost impossible to prove. And since the codification of the law in late 1948 in the convention, you've had, of course, the rise of Holocaust memory, which wasn't the case at the time. And now the way people reason is they say, well, the primary genocide of history is the Holocaust. So for something to be a genocide, it needs to resemble the Holocaust. And you see that reasoning again and again, even apart from the Genocide Convention. But I do think that when you read the judgments of the ICJ, especially in the Bosnia case, you see, and also the ICC, you see that they separate military intent from genocidal intent, although Lemkin joined them. Because genocides were wars of extermination, wars against entire peoples, right? Which is what was going on in Bosnia, right? By the Bosnian Serbs, right? It was a war against the entire Bosniak population in order to create a greater Serbia. But in one of the judgments, the judge said the attempt to create a greater Serbia is a separate intent, and it's not a genocidal intent. A genocidal intent means just, like a Holocaust-like intent to destroy Bosniaks simply because they're Bosniaks. It's a separate sort of apolitical logic based on a massive hate crime calculus. And that doesn't occur in reality. In reality, attacks on peoples are always mixed with security and military motives, right? The two go together. That's the reality that historians and social scientists see when they study mass violence. But the lawyers, when they get into the courtroom and make their pleadings to the judges, they have to somehow pass them out and infer that there's a Holocaust-like intent to destroy a group simply because they're a group. Now you don't like them, and not because there's a causal nexus related to an armed conflict. But you look at virtually all the cases of mass violence against civilians since the Second World War. They're always in cases of armed conflict, whether internal armed conflict, a civil war, a rebellion, or an external armed conflict like with Ukraine.
Yeah, you've already drawn the link to the present, and we've just recently seen that on January 3rd, the US has attacked in an act of aggression the territory of Venezuela. And in the past, many of the breaches by US military have been justified by a notion of American exceptionalism. And in your understanding, what role does exceptionalism, the notion of exceptionalism, play in the commission, the classification, and the justification of war crimes and of genocide?
So, so no one's alleging war crimes or genocide or crimes against humanity in this current event in Venezuela, of course, but it is central to the South Africa case at the ICJ, and of course to the ICC indictments against two Israeli leaders and against two Russian leaders. Now, what I'm observing is that great powers, or as Stephen Miller said on television yesterday here in the US, a superpower like the US, don't need to abide by any of these international rules and norms in their own spheres, in their own Großraum, to use a German concept from Carl Schmitt, which is very current in the German debate today. So spheres of influence is the term we use in English. And the Russians are claiming that entitlement in East Central Europe, and the Americans now in the Western Hemisphere. And that, in a sense, has been the unwritten law of international relations for centuries, manifested, of course, in the Monroe Doctrine long ago here in the US, which Donald Trump explicitly refers to. And the Russians talk about the near abroad. A lot of ethnic Russians living in Baltic states, in Ukraine and elsewhere. And Russian elites claim effective sovereignty over wherever Russian populations live. It's a slightly differently articulated notion of the sphere of influence, but there's an ethnic dimension to it. But it's one nevertheless. And there, the rules-based international order, a term that people like to use, which was established after the Second World War, where there's a non-interference norm embedded in one of the very early articles of the UN Charter, that has always been paid lip service to since the Second World War, but no longer. I mean, now it's explicitly rejected by Russia, although it denies that it's doing so, but by Russia and by America. China's interesting because it tries to extend its influence without breaching that norm by cultivating tributary states and so forth. But the blatant disregard for these norms by some US commentators or leaders or advisors today is remarkable to observe, but has a deep history. And everybody's now wondering what the future holds.
In many discussions about genocide, I've noticed that scholars refer to categories of evil or other allusions to biblical terms or notions of divine concepts. You've also discussed the concept of apocalyptic conjuncture in the past. Does a discussion of the crime of all crimes, genocide, necessarily entail the notion of religious or theological categories? Or how can we understand that as legal scholars?
Yes, that's a tricky one as well. I do think that these theological categories are smuggled in uh, uh, and often implicit in many of the judgments which are made or distinctions which are made in judgments. I mean, the notion that genocide is the crime of crimes is, of course, not a legal one. It's a cultural one. And yet, when you read legal commentary, they give away their acceptance of that proposition by saying something that, these events could be a war crime, or they could rise to the level of genocide. You know, this is a sense of hierarchy, because rise is a vertical metaphor. So you do have an implicit hierarchy of international crimes, genocide at the top, then crimes against humanity, and then war crimes. I mean, I think this is a real problem. And I know that it's not embedded in the Rome Statute, but that's still how people reason and how they imagine evil. And it's incumbent upon cultural historians to explain to us how and why this came to pass. Why is genocide considered the crime of crimes when, as it was formulated in the mid-late 1940s, the supreme crime was a crime of aggression, as you know from the Nuremberg trial, from the International Military Tribunal. But that was quickly forgotten in the context of the Cold War. And the Holocaust archetype as the supreme evil, which informs the genocide concept, or came to inform it, took over. An atrocity paradigm is what Lawrence Douglas calls it. He's a professor here in the US. So that lurks in the background. Now, I think to that extent, the discourse about calling something a genocide is really a discourse about whether something is supremely evil or not. I mean, it's a moral discourse as much as a legal discourse. And that's why victim groups fixate on wanting to call their experience a genocide and not, quote unquote, just a crime against humanity. Although they can involve the same acts, as you know. And a crime against humanity includes the case of what's known as extermination, which is a distinction without difference from genocide. I know there's an intent requirement in genocide. But if you ask anybody on the street, what's the difference between genocide and extermination? They couldn't tell you. For them, it's the same thing, right? So what is this surplus charge in the notion of genocide? Well, I think it is related to the Holocaust and the Holocaust centrality in our memory culture as the greatest evil in human history, which is what it has become. And not just in Western culture, but globally. If there's a United Nations Holocaust Memorial Day in January, for example. It's not just a Western discourse. I think the reasoning is like this: because genocide's archetype or ideal type is the Holocaust, then anyone who wants to claim something as a genocide is also arguing that somehow it's also like the Holocaust in some respect, in some important respect. Okay? And it's got to do with this demonic evil intention to destroy. It's not the results, it's the intent. Like it's an evil intent, something sort of demonic, which I think is very problematic too. And it leads to, for example, to the categorization of Srebrenica in 1995 as a genocide in which 8,000 men and boys are killed, right? I mean, it's a terrible event, but 8,000 is a lot less than Palestinians have been killed in Gaza, okay? But people struggle to call that a genocide. And I'll give you another example, which I think gets to the absurdity of this situation. So, advocates for Israel argue that Hamas possessed in a genocidal intent in its actions on the 7th of October 2023, in which over 1,000 people are killed, many of them civilians, quite a few of them are soldiers, incidentally, and not all of them Israelis, but most of them Israelis. But still, say 700, 800 civilians, which is a lot of people massacred virtually with your bare hands, it's light weapons, in a couple of hours, right? No doubt a terrible event, and the ICC has, called this war crimes at least, right? Now, these same people who insist that Hamas is a genocidal actor and attempted genocide on the 7th of October will deny that Israel's killing of over 60,000 Palestinians, at least a third of them children, and that's no doubt an undercount, and the complete laying waste of Gaza through starvation and the wanton destruction of infrastructure, that's not genocide. although we're talking about 60 times more people. Like, that's not genocide. That's collateral damage in an act of war. There may be a couple of war crimes here and there, but on the whole, it is perfectly just. Now, it's this anomaly, if you like, in international law that propelled me to write this book on the problems of genocide. But that is a problem of genocide. If it's okay to massacre 60 times more people in self-defense against a genocidal entity, what does that tell you about the genocide concept and its function in international relations?
Thank you. In your article to the German legal journal Kritische Justiz, you've discussed the activities of civil society tribunals, like the Russell Tribunal in the Vietnam War. We, as German lawyers for international law, have also hosted our own Gaza tribunal in Berlin for the German commitment of atrocities and support in genocide in Gaza. Which role do these civil society tribunals play in the assessments of international crimes if official institutions fail to do so?
Well, they're very important, but their significance may only be apparent over time. Now, we know that the German press largely ignores or tries to ignore what you're doing, right? Because they're on Staatsräson message, right? The senior editors and owners of German newspapers see themselves as administrators of what I call the German catechism, or keeping the discipline of the Staatsräson against public opinion, which they don't trust. Okay. So they're going to ignore what you're doing. However, you're doing a number of things which are very important. A, you're gathering evidence and setting a record. That's extremely important, and putting things on the record so that in the future, and hopefully in the not too distant future, people who want to investigate these issues have the records ready at hand. And it can be said that there were people in Germany who did try to do the right thing, who did respect international law and to hold people account to it and to be consistent. We don't know what the future holds, but I call these kinds of efforts, including some of my own, Flaschenpost. These are messages in the bottle for the future. And it makes those of us who come after us, it makes their job much easier if you've done the work that you've been doing there.
In your book, Nach dem Genozid, you state, Gewalt ist die Folge des Gebots dauernder Sicherung. Violence is the consequence of imperative of permanent security. What do you mean by that?
So the notion of dauerhafte Sicherung was a common one in Germany in the 1920s, 30s, and 40s. And at his trial for running Einsatzgruppen D, Otto Ohlendorf used this concept. He didn't invent it, but he adapted it or adopted it in his defense when he was asked by the prosecutor at Nuremberg, why he killed Jewish children. And he said, you have to understand, the Nazis were not engaged here in just regular security. We were in dauerhafte Sicherung, or permanent security, or enduring securitization, which means we have to act preemptively, or prophylaktisch, you would say in German, right? You've got to kill future threats. So Jewish children will grow up to be partisans or opponents of the Nazi regime. So you've got to kill them now. It's like a terrible logic. And of course, this didn't help him. Like the court said, this is an outlandish threat perception, and we can't take the subjective paranoid threat perceptions of actors as legitimate defenses. And they rightly convicted and hung him. Okay. But what is so interesting about his reasoning is that it unveils the inner logic of mass killing against civilians generally. But anyone who's engaged in the comparative study of violence would have seen that logic about killing children of your enemies so that they can't come back like in Terminator with those temporal slippages. They can't be enemies in the future in many places. So I, as someone who's written quite a bit on colonial violence, saw this in documents where people say you need to kill the nits so they don't make lice. Nits are, das sind kleine Läuse, right? You've got to kill the baby lice so they don't grow up to become a nuisance, right? So you've got to kill indigenous children now so they can't become warriors, or the girls can't become mothers who bear warriors in the future. So you're future-proofing your expansionist project. These are usually undertaken in the context of geographical expansionism or in putting down insurgencies. So you want to make sure there's never an insurgency in the future. Well, you kill their children, among other things. Okay. Now, this came up in a stunning way at the Fritz Bauer Institute in December 2025, when Moshe Zimmermann was giving a talk about German memory culture. In fact, he said how German memory culture had, the Holocaust Kapitel is verspielt worden, or something like that. Like, it's been gambled away. The capital, and he explains what he means by a capital. He doesn't mean it in a monetary sense, but he means it in a sense that a credit, like Jewish people, Israel got a credit after the Second World War because of the Holocaust, and that credit's now been exhausted at the bank because of the conduct in Gaza. Now, he's arguing that, not me. Okay, I'm just observing this. Now, his discussant was Jürgen Kalber, the editor of the Frankfurter Allgemeine Zeitung, who was a bit shocked by all this, and then went on for quite some time about how genocide is not taking place in Gaza, with that logic that I explained before. It's because he said it doesn't look like the Holocaust. He didn't say that explicitly, but that's how he reasoned. He said, Israelis are not just picking off Palestinians because they're Palestinians. I mean, this is a military conflict, even if it's asymmetrical. And, it's not as if the Hind Rajab is like Anna Frank. I mean, she was caught up in a firefight, whereas Anna Frank was hiding in an attic in Amsterdam, and she was a threat to no one, right? She hadn't done anything wrong. So without him realizing it, he was basically ascribing collective guilt, a collective vicarious guilt, even to Palestinian children, and saying that, although he didn't think it's a good idea, he talked about the excessive nature of the Israeli campaign, but his main point is not genocide. It's like he's engaging in this hair splitting, which I think is despicable, because the conversation shouldn't be about, well, is it genocide or not? It's like, why is Israel killing so many Palestinian children, regardless of what you call it? Okay. This is what I mean by one of the problems of genocide. We get fixated on these little technical matters, trying to determine whether something is this demonic intent, like Himmler or Hitler or something, always looking for Hitlers and Himmlers in history. At that point, Moshe Zimmermann turns to him and says, well, it's all in German, incidentally, but if you look at what the right wing in Israel is saying, including ministers in the government, they are saying that. They're saying that the women and children are equally guilty and they deserve to die as well. And he then says, it reminds me of Himmler's Posenrede in 1943, where Himmler, standing before a mountain of executed Jews, says that we remain decent in annihilating, although it was difficult, Jews who would be a future threat to us. And the word that Moshe Zimmermann uses is prophylaktisch. Man muss prophylaktisch handeln. And he says these Israelis who are also in the government are basically like Himmler. And everyone's stunned because you can't say those things in Germany, right? And no one knew what to say. And of course, what he's saying, apart from breaking this taboo on this comparison, is that permanent security was the logic, because the prophylactics means preemption, and preemption is the key element of permanent security.
In your Zurich lecture in December 2025, you argued that many people in Germany now perceive official Holocaust remembrance as lacking credibility because it is being used to justify support for Israel's action in Gaza. Where do you see this loss of trust in Germany's culture of remembrance leading?
So let's get the facts out there first. From the polls that I read recently, only 10% of Germans believe in the Staatsräson as articulated by Angela Merkel in 2008. That means 90% don't believe in that. Well over 60% of Germans think that German foreign policy should be governed by universal values and international law. At the same time, they do think Hamas committed war crimes, so over 60% on the 7th of October. 59% of Germans think that Israel is committing genocide, and over 60% war crimes. Okay. So the German public, I think, has quite a balanced view on these things. It's not an anti-Israel view, because they're also critical of Israel, of Hamas, and they do think Hamas should have released the hostages much sooner. So what I'm seeing in the German public, or its reactions, its moral pulse, its moral sensibility, is that the German public, by and large, I mean, I'm leaving aside, the 20% AfD voters, has learnt the Holocaust lessons. They have learnt the lessons of the past, which is that nie wieder, a genocidal war, whether it resembles a Holocaust or not. But everyone can see what's going on in Gaza is a flagrant violation of international law, however you categorize it, and wrong. And it's wrong that the German government supports it. Now, the German government barely registered that. Merz made a few comments in the summer of 2025 to say that he no longer understands Israeli war aims. And there was a temporary freezing of some deliveries of parts of weapons and so forth. But that was quickly resumed, and it's business as usual, despite what the German population thinks. I'm actually rather pessimistic about whether popular opinion can be expressed or articulated in policy, because the German political class, which enforces the Staatsräson and the Catechism, is firmly committed to these foreign policy settings, which are, of course, connected to an Atlantic alliance, to the US and so forth. And what it seeks to do is just manage this popular opinion issue or public opinion issue so it doesn't get in the way. In any event, most Germans are more concerned about energy prices than Palestinians, right? And there's also, one way of diverting this is to blame foreigners for everything that's going wrong and increase Islamophobia, and that's succeeding quite well.
Yeah, let's stick with an eye out to the future, because in Gaza we've seen the emergence of a wide scale of use of artificial intelligence in warfare for the first time. Is the alignment of the definition of genocide along the category of specific intent still timely in today's time, when human judgment retreats from the battlefield?
So, I mean, I've never thought that the specific intent requirement of genocide is a very good idea, as I've mentioned earlier in our discussion. Whether the AI or the use of AI makes that even more difficult remains to be seen. There are a number of publications coming out now, and I published one or two of them in the Journal of Genocide Research, where scholars, based on little information, because we only have those leaked interviews that were published on 972 Mag, interviews with drone operators on the Israeli side, who explained how the software Where's Daddy and Lavender work, where the scholars have wrestled with this question of intent. But I think we need to put the use of AI in a slightly broader context. For example, the AI identified what were believed to be Hamas targets based on telephone usage, right, cell phone usage, regardless of who had the cell phone in their hands at the time, but it was based on this pattern of usage. And so low-level Hamas operatives who were targeted in a way that did involve human judgment and therefore questions of intent in two ways. The first was the decision through the Where's Daddy software to wait till the target entered their home rather than being outside. And that way, it was obvious that you were going to kill everyone else in the building. Now, why would it be everyone else in the building when we know Israel has very precise munitions, like they used in Iran, where they can pick off someone in a room, in an apartment block? Well, those are very expensive. So instead, they use those 2,000-pound dumb bombs, which destroy, several football fields of territory in a very dense urban landscape, in which you're inevitably going to have dozens, if not hundreds, of casualties each time, and entire families, which is what happened. And that's why there are so many women and children in the death toll. Now, when we come to questions of specific intent, you can see how idiotic this quest is, quixotic and Sisyphean, because there's clearly a mixture of military and genocidal intents. How can one say that the killing of these women and children, along with the Hamas target, is not intended when you waited for him to enter the house knowing that the house is full of his family members and that you're going to use an ordinance like a 2,000-pound dumb bomb? I mean, clearly it's not unintended, it's not collateral, right? But does it satisfy the specific intent requirement of the Genocide Convention as it's been interpreted by the ICJ? Well, we don't know yet. Okay. I mean, that's what a number of us are trying to tell the judges, and I'm not the only one, right? So this mixture of military and genocidal intents and affects or effects needs to be grasped by the judges so that they can put aside this archetype of genocide that they have in their mind, which is based on World War II movies of Nazi perpetrators.
And regarding to that, later this month, the ICJ will hold the oral hearings in the genocide case of Gambia versus Myanmar, which is deemed to set a precedent for the South Africa versus Israel case. In your informed opinion, how should the court adapt the criteria for genocide in this case?
Speaking honestly, I've not read the documents. Are they publicly available yet for those hearings?
I don't think so.
Yeah, so I'm speculating here now. But what we're dealing with is, if you like, a genocidal ethnic cleansing. My understanding is that the death toll from 2017 onwards is about 30,000, and we're dealing with an expulsion of about 750,000 people. And the facts are then slightly different to Palestine or Gaza, where you have far more deaths, but the inability to expel a population because the borders are sealed. Okay? Egypt won't let these people out. So Israel now has these people on the inside and is subjecting them to starvation over the last year or two. Now aid supplies have gone up, but now the weather is doing genocidal work by forcing Palestinians to live in flimsy tents while they're buffeted by winter storms. And so the effect of pushing people into the desert, which was the case in Namibia or German Southwest Africa before the First World War, and in the Armenian genocide, where most of the deaths occurred in the expulsion of or deportation of civilians into the desert, where people died of exposure. Right? That's what you're seeing now in a slow motion way in Gaza. And that's not the case in the Gambia, where the refugees found, a tenuous foothold, mainly in Cox's Bazar in Bangladesh. Okay. Now, the ICJ, because of the way the law is written, has to determine whether there's a genocidal intent in the conduct of the Myanmar military. The Myanmar military will argue that it was engaged in a counterinsurgency campaign against a separatist group. And there is a separatist group, or there was, well, actually still is, in that part of the world. And this is where permanent security comes in. And this is where the judges need to think a bit more broadly. So the options open to the Myanmar military were to confront the insurgency in a very direct way and incarcerate and prosecute those that are responsible for it. We're talking about several hundred people, okay, maybe several thousand, but not 750,000. So the Myanmar military, however, reasoned in terms not of immediate security, but permanent security. They said, we never again do we want to allow and have the conditions of an insurgency in the future. And the only way to do that is to expel the population from which the insurgents come. So you're engaging here in one element of permanent security is collective guilt. The collective as a whole is vicariously guilty or potentially guilty. And then option two, or element two, you are engaging in preemption. You're expelling in a murderous way through, burning of villages and executions and so forth, through terror, an entire population to ensure that this border region of Myanmar is no longer going to be a contested region for the state. And the insurgents have no sea to swim in anymore. So you have to drain the ocean. It's classical counterinsurgency thinking. And it's been done very much in a genocidal way. So unfortunately, from my understanding of the text, is that the way that the applicants for the Gambia are going to have to reason is to say that they attacked Rohingya solely because they're Rohingya, the as such element in the Genocide Convention. And, that's partially true. When they're attacking, women and children and civilians who are not involved in the insurgency, they are attacking them as such, simply because they're Rohingya, right? But in the minds of the military, is not based on a hate crime. It's not because they're Muslims or so forth, they belong, although these pre-existing prejudices are significant there. It's because they're reasoning in terms of permanent security. And that's genocide as a concept only partially captures that because it depoliticizes the logics of permanent security by saying that populations are attacked on the basis of racial antipathy and not also because they're seen as a threat. The threat perception is very important. Otherwise, one has to ask, well, why didn't this happen 100 years ago or 50 years ago? Right? There are security crises which states have to deal with, and it's in those crises that permanent security solutions, which are clearly illegal, come to the fore and are executed.